going to call the meeting to order. Welcome to the House Judiciary Non-Civil Committee meeting this afternoon. This is a continuation of a meeting that we actually started last week on House Bill 147. When we concluded last week the discussion, which I thought was a very good discussion between the author of the bill, Chairman Mills, and the members of the committee, cut short time for testimony from those who care about this bill, either proponents or opponents. And I wanted to give some time out of fairness for the people who had come. And I'm not sure that, given the fact that session has gone longer than we expected today, and we had another subcommittee meeting, we're going to try to go until, I know other members have already been telling me they have other commitments, either here on the Hill or back in their districts this evening. And so we're going to try to go till about 6 o'clock today. And if we don't get to everybody, then we'll have another discussion. Disappointment? Oh, I would never be, I wouldn't want that on my conscience. So that's our plan. And we have, I didn't count today, it's not 17 people. We do have a number of people signed up. And we're going to hear from everyone. I would ask you, out of respect, to be concise. And I say out of respect because there are others that want to be heard also. And so that's where we are. We're going to start, and if you would, as I recognize you, and then the members of the committee will be given an opportunity to question you, I've told Chairman Mills, who is here, thank you for being here, that I thought he got a fairly thorough grilling last week. And so we're, I know I'm going to disappoint Representative Randall when I say this, but she's going to have to rest up and take another shot at him at a later date, okay? But I didn't mean to single you out. If you would, when I call your name, come up to the podium, tell us who you are, the organization with which you are affiliated, and then give your statement, and then we'll recognize members of the committee. I'm going to start with Sarah Cook. Podium is over here. Yeah.
Good afternoon, Chairman and members of the committee. My name is Sarah Cook, and I am currently the interim director for the Georgia Network to End Sexual Assault. I spoke with you all last year because I'm also a victim of a sexual assault. In 1993, a man broke into my townhouse while I was a graduate student at the University of Virginia, bludgeoned my head with a tire iron, and sexually assaulted me. I'm fortunate that I survived. I'm here today to say that I have countless indelible images that remind me of my assault. Every day when I look at my left hand, I see my middle finger that was smashed and no longer functions. I see the top of my thumb, which was torn off, but luckily stitched back on. If I brush my head against something, I feel scar tissue. I have odd referent sensation in my head where if I hit my head over here, I might feel it over here. It reminds me of those blows of the tire iron. I have an image of my x-ray of my hand. And finally, it's somewhat ironic that today as I walked over here, it's a beautiful day that makes you think about spring. My assault was on May 18th, excuse me. And so I have a particular image of springtime, and instead of one that brings delight with flowers and warm weather, when I feel that warm weather coming back, I feel a sense of doom and dread, extreme anxiety. I had that today. I have lots of images. If I were to have been impregnated by Derek Lamont Jones, the man who broke into my apartment, I wouldn't have wanted another image. to see to remind me of that assault. I wouldn't have wanted to have to defend myself, in essence, against the question of whether I wanted to see that. I had to defend myself plenty. I defended myself in my apartment. I had to defend myself in the courtroom when the defense attorney suggested that this was really a sexual tryst which had gone awry. So I ask you on behalf of rape victims, please make an exception in this bill. Do not offer women another image that they will have for the rest of their lives in their minds. And don't ask them to defend themselves in that very sacred place of a physician's office where they're seeking medical care. I'm happy to answer any questions.
Members of the committee. No questions. Thank you very much for being with us.
I appreciate your time.
I neglected to make some subcommittee assignments, and I'm going to jump in and do that right now. If y'all want to make a note of this before we have the next speaker, I'll do this fairly quickly. I'm assigning House Bill 285 by Chairman Ron Stevens to Subcommittee 2. That's the Mumford Subcommittee. House Bill 286 by Chairman Stevens, also to Subcommittee 2, the Mumford Subcommittee. House Bill 314 by Representative Neal to Subcommittee 1, the Knox Subcommittee. House Bill 316 to Subcommittee 2. House Bill 334 to Subcommittee 2. House Bill 336 by Representative Levitas to Subcommittee 1. House Bill 355 by Representative Lunsford to Subcommittee 1, and House Bill 356 by Representative Talton to Subcommittee 2. Everybody get those? Okay. I made a comment or two about being fair today, so the chair from the well on another unrelated matter. So the chair is going to exercise its prerogative to sort of go from one side of this issue to the other. And I think that's the only fair way to do it, and so we get balanced. Carol Swift.
I am Carol Swift, President of Georgia Right to Life, and I am speaking on behalf of this bill. It is an extension of the woman's right to know, simply common sense information that a woman needs before she would make a decision whether or not she would have an abortion or not. So any woman considering an abortion should have this information.
You were brief.
Very brief. Very brief.
Questions from members of the committee? Representative Mangum.
I was not here at the last hearing, and I did not get the benefit of some things, and this may not be the witness to say this, but what is different in this bill than last year's bill that passed out of the committee?
Last year's bill was we did not have a list of the pregnancy centers that offer free abortions. Ultrasounds, excuse me. We did not have penalties in the bill last year.
Further questions? Representative Randall.
You said that there are certain things that the woman needs to know that will be determining factors whether or not to go through with abortion. What are those things that the woman should know that she does not already know?
Well, to get an ultrasound, you have to have a pregnancy test.
And
so you would have a pregnancy test, and then the doctor or the facility would order an ultrasound to know we went through all this last time, the gestational age of the child, position, if it's an ectopic pregnancy, if it's twins, triplets, quadruplets, whatever it might be.
Okay, that's enough. Let me ask you this. We're both women. I'm not understanding why you sent a pregnancy test? You mean to tell me you think a woman would go to an abortion clinic and she's not sure she's pregnant?
To have a pregnancy test, yes, they do.
No, I'm saying what information from the sonogram, from the, what are we talking about here?
From the sonogram.
Ultrasound.
Mm-hmm. Same thing. Sonogram, ultrasound.
Okay.
Just those things that I just listed would be from an ultrasound or a sonogram.
And you think those things are absolutely necessary, even though she's already made the decision as to what she wanted to do?
I would ask you, why would we not want to give her that information?
Well, I think it's one of those things that if she wants to have that information, and I just think the whole point of this bill is just undue burden.
But you just said the key thing. She has a right to choose. All it is an offer. She can decline it. She can decline to view the ultrasound.
Thank you.
Further questions of Ms. Swift, members of the committee? Representative Abrams.
The ability to choose. Would you be comfortable with the ability to choose to decline to have an ultrasound taken? Going back to the previous speaker, who was not willing to endure a second opportunity to face the trauma that assailed her, would you be, given that you did posit that this is about the right to choose, why should women not have the ability to choose not to undergo an ultrasound?
For her own safety. What if it's an ectopic pregnancy? She would need that information.
Well, this bill does not. I would say to that, in certain circumstances, the doctor would determine whether an ultrasound is medically necessary. This requires ultrasounds whether they are medically necessary or not. Would you be okay with a bill that required the performance of an ultrasound in medically necessary circumstances, but with the woman having the right to choose whether to undergo that procedure, because it does create a second step in the decision-making process for her? Given going to your core point that this is about giving women the right to choose, why should women not be allowed to choose to undergo an ultrasound as opposed to having that burden imposed upon them by the state?
The answer I just gave you, for her own safety.
But her safety only matters if it's medically necessary. So my question is, taking into account your point about her safety, if the doctor determines that there is not a safety issue involved, if it is not medically necessary, because if it is about her safety, it becomes medically necessary and therefore falls under a different parameter. Why?
It is standard of care already. Last year when we had our bill, everyone testified that they were already doing the ultrasound. Even the first trimester, it was already being performed. And if you go out on the website and you look at abortion facilities, they say they already perform them.
Then can you speak to me about why, given that you say that it is already being performed, that if it's medically necessary, a doctor will, under the standard of care and therefore by law, perform the ultrasound? Going to your core point about giving women the right to choose, I see a bit of a disconnect between the right to choose to undergo an ultrasound and it being if it's not medically necessary, and the imposition by the state that this be a determination made by the state and not by the woman and her doctor.
It's ensuring that it would be performed and that she would be offered.
But going back to your point about the fact that it's already performed, why wouldn't this happen absent? So I guess my
let me just give you an example.
Actually, may I finish my question, please?
Yes.
And feel free to add your point into your response, and this will be my final question. It would seem to me that you have a bifurcated set of circumstances. You have medically necessary circumstances wherein a doctor under the required standard of care will perform an ultrasound, and as you stated, that is a standard practice by all obstetric facilities, including abortion clinics. On the other side, there is the medically unnecessary test that a woman can either choose to undergo or choose not to undergo. And this bill would remove that choice. This bill would say that regardless of a woman's decision, regardless of a woman's consultation with her doctor, regardless of the doctor's best medical knowledge, she is required by the state to undergo a procedure. A doctor is required by the state to perform a procedure. That, to me, flies in the face of your underlying premise, which is giving women the right to choose. So if you can explain to me how this is providing a choice to women when it is mandated, it seems to me that those two things are inherently in conflict.
It's the choice comes with viewing. The choice comes with viewing. If you go in now, according to testimony last year, if you go into a facility that you're considering an abortion, they will do an ultrasound. We want to require that. We believe it's standard practice. We've been told that it's standard practice, but we want to ensure that it is performed. And the right to choose comes from the viewing.
Good. Representative Levitas and
To the Madam Chairman, I'll certainly wait.
oh, you know how to win points. You must. You're learning fast. Chairman Cooper.
One of the major differences in this bill this time would be on page 6 and line 31 through 36, which would make last year's bill, when it finally came out of the committee, said that if there were violations, that reports and complaints could be made to the medical society. And one of the major differences in this bill is it sets up something, and I'm not sure there's any other place in the law, I'm not a lawyer, that would make if you didn't do this, would automatically make it a malpractice case, and saying that it is definitely malpractice. That's a major difference, and I think there's also a difference for making it a felony or a misdemeanor. And isn't that not one of the two of the major differences in the bill that passed?
The penalties, when I said penalties, but it does not automatically make it malpractice. It says that it provides a basis for malpractice.
Well, I think that it certainly opens it up of a failure to obtain informed consent. I think it opens it up for it to be considered a malpractice case, and also in the felony.
Provides a basis.
Are you aware that Georgia is already has far below the number of OBGYNs that it needs per 100,000 people to deliver normal, healthy babies across the state, and that we have areas in our state that people have to drive, women have to drive 85 miles, a diameter of 85 miles to get to an OBGYN just to deliver to the babies that are wanted, and that this kind of bill with those kind of penalties would greatly interfere with people trying to recruit young OBGYNs to come to the state to do regular, not abortions, just to do regular OBGYN care for our citizens.
If they're only doing regular OBGYN care, they have nothing to fear because they're not performing abortions.
Ms. Wood, do you realize that in the regular practice of medicine that physicians do what is called, when people have spontaneous abortions and so forth, that they do have to take care of those?
Yes, and that definition of a spontaneous abortion is not it's not defined in this bill.
I mean, I would say, and I'm sure your intent probably is not to go after our regular OBGYN doctors, but I would tell you the way this bill is written, they feel the pressure, and we're getting the calls about how they feel like it could be misinterpreted or they could be gone after for just doing their regular job of trying to deliver healthy babies to the citizens of Georgia. Thank you, Mr. Speaker. Mr. Chairman.
Was that a question?
No.
Well, after that, you get another question if you want it. Representative Levitas.
Thank you, Mr. Chairman. Thank you for being here, and I appreciate you being up here and advocating for your position. I want to touch first, if I may, Mr. Speaker, touch on two areas. Mr. Chairman, I've done it myself, but on two areas. I want to start with one of the provisions for civil recovery, and I want to touch on a little bit different one. This is under Section 6 On the bill that I have, it's page 7, line 3 to 5. It's the subparagraph 3. As I read that provision, failure to provide the sonogram in this case would be a strict liability basis for a wrongful death if the abortion is then performed. I know you're not a lawyer. My understanding is you're not, and I'm not asking for a legal opinion, but do you have a different interpretation of that statute, or do legal counsel that work for you have a different interpretation, or is it the intent to make this a strict liability, quote-unquote, offense for failure to do a sonogram, providing a basis per se for wrongful death?
I'd like to defer to the attorney that we do have here, if I may, Chairman.
Okay. Can I reserve the answer to that question for just a minute, Mr.
Sure.
Chairman? Let me go into the second question then. Chairman Cooper touched on this a bit. Are you in support of the misdemeanor punishment for failure to comply with this code section?
Yes.
Okay. And in a lot of instances like shoplifting, public indecency, there's actually a bill pending now to make failure to have a valid license on the third offense a felony. All of those offenses for repeat offenses at some point become a felony. Would you also support then a provision that makes a doctor who violates this code section multiple times susceptible to be convicted as a felon?
I don't think I'm qualified to answer that question. No, on the surface, I would say no.
And what would be the difference to you between punishing the person? I'm going to assume for purposes of this that a misdemeanor is going to be punished by up to 12 months in prison and a fine, or 12 months in jail and a fine.
And I believe that's flagrant violation.
And my question is, let's say you had a doctor at an abortion practice who had done this, flagrantly violated this statute 5, 10, 15 times in defiance. Would it be your position that there should be enhanced penalties, for example, multiple years in prisons, higher fines for a person who, a physician who violates flagrantly the statute on multiple occasions?
I am not supporting that, no.
Okay. So, but you do support incarceration for up to 12 months for someone who violates.
Misdemeanor, whatever that penalty is for misdemeanor, yeah.
If you'll indulge me that that's 12 months, would you say that, yes, you would support incarceration for up to 12 months for a doctor who violates?
If this bill is passed, yes, I would.
Yes, ma'am. Thank you. Thank you for your time. Thank you, Mr. Chairman.
Representative Collins.
I think she's left the podium. No problem. Just a quick question. Thanks for this. I've been listening to the questions, and they're very thought-out questions. I appreciate that. The question came up of undue burden. Is it not true that in the Casey decision that the court declared that undue burden, in the way it was read in that part, could include states with a state's interest in not only life but also other issues, that they declared undue burden would not be met by having such things as the woman's right to know, and also even taking it up in the court actually said in some ways financial cost associated with it. They did declare, I'm reading that correctly, that they declared that was not undue burden.
Yes.
That is correct?
Yes.
Okay, thank you.
I don't see any further questions. I was trying to get you off the hot seat.
We have experts that could give you much better answers, I'm sure.
Chairman Franklin.
I appreciate it. Thank you, Mr. Chairman. We had heard someone earlier testify about the tragic rape that she had undergone, and that is a tragedy. And one of our members also addressed that testimony. In the state of Georgia, at one time, the rapist received the death penalty. Is that not correct? If the rapist were convicted, wasn't rape a capital offense at one point in Georgia?
I'm not sure of that, Bobby. I'm not.
Well, is it your opinion that the child should receive the death penalty because of the sins of the father?
Absolutely not. The child should not die for the sins of the father.
Thank you.
Okay. I see no further questions. Thank you, Ms. Swift. You'll have to excuse me if I don't know which side of the issue you're on. Adrienne Martin. Did I pronounce your name correctly?
Very well.
Thank you very much.
Good afternoon. Thank you for letting me be here. My name is Adrienne Marting. I'm a healthcare attorney here in Atlanta. I've been practicing for about 18 years. And I'm also here on behalf of Planned Parenthood. I serve as their general counsel. They asked me to talk to you a little bit, just in general terms, from a legal perspective, some of the issues regarding this bill. And I'd just like to give, I know my time is limited, I'd like to just go in summary fashion and then we can get into specifics. First of all, there's a very good chance that the way this bill is written, and all due respect to Chairman Mills, but that it could be viewed and found fairly easily void for vagueness. The standard there is that if intelligent minds could differ on how a particular provision could be enforced or understood, if it lacks clarity, that may be unconstitutionally void for vagueness. And this bill, as written, is highly subject to that finding. Secondly, it's possible that it would fail under the equal protection provision of the 14th Amendment. What the effect of this bill, as one of our panel members mentioned, it will adversely affect the most individuals in the outlying areas, not the people around Metro Atlanta, not the people who are well off, but the indigent or less fortunate in rural areas that don't have an access to health care right now, much less to have a baby, but this would hinder their ability to seek an abortion as well, and especially an early abortion. Clearly, this provision is a blatant intrusion on the physician-patient relationship. I was here at the last meeting, and many times the term standard of care was mentioned. It seems to me that this legislative body is trying to step into the footsteps of ACOG, the American College of Obstetricians and Gynecologists, and set the standard of care. In malpractice, the standard of care is what's generally knowledgeable in a particular area. If you look on the websites for a lot of the information on this bill, on bills like this, talking about ultrasound, a lot of the people on the other side of the aisle from me talk about the 3D and 4D ultrasound that gives the very highly specific images early on. That is not the standard of care in the industry. They're not going to get what they're asking for. If you go to OBGYNs all across the state, you go to the medical centers around here, Planned Parenthood, Feminist Women's Center, all the abortion providers, none of them provide this very high level ultrasound. So we're talking about imposing, if that's in fact what they want to do, it's not stated in this bill. And if it is, it's an undue burden to all those providers as well. And it's important to know that the test that they're asking about is not the tummy rub when you're pregnant that you get in your second trimester and they just rub a little gel on your tummy and it's not very invasive. During the first trimester, it's a metal probe that is inserted into the vagina, up into the uterus, and the ultrasound is done that way. So it is an invasive procedure, and you just need to know exactly what's involved. Another key factor is the expense of the procedure. I know that there is a provision in here that talks about free clinics. What it doesn't talk about is who's providing those free clinics. How are they monitored? We call DHR, the Department of Human Resources for Georgia. They do not require licensure by DHR if a facility that has a sonogram machine. So anybody on their street, what we were told is you only have to have a business license. So this opens up all sorts of things with respect to the quality of care, who's going to monitor these, who's the providers, who's actually going to do it. Are they going to be subject to malpractice? Are they going to, if they claim they're going to have a medical director over those free clinics, does that subject the medical director to malpractice if these aren't read appropriately? it just opens up the floodgates of litigation. And more importantly is that it wastes precious resources. All of you know that Medicaid, Medicare, Peach Care, all are hurting, all are being diminished. The funds that are available need to be used wisely, and the most effective way to be used is to prevent a pregnancy from even happening. That's easy, it's much less expensive, and the focus certainly should be there. And not to mention, I mentioned a little bit about malpractice. A lot of progress was made previously with respect to tort reform, and this just opens up the concerns of the OBGYNs who have been driven out of the practice because of increasing malpractice rates. The danger in these rural areas, the way the statute is written, it doesn't just say the abortion provider shall provide a ultrasound. What it says is the abortion provider, the referring physician, or any of their agents shall inform the patient that they are required to have an ultrasound. It doesn't say who has to do the ultrasound. Doesn't have a specific time limit on it, and so the referring physician, who oftentimes may be an OB, doesn't know if they're going to be subject to violation of this provision. There's no follow-up. Basically what this rule is doing, this is saying the woman has to have an ultrasound. But the way it's written, neither the abortion provider nor the woman affected by this, the woman who had the invasive test, has to view it. So this is clearly medically unnecessary. The way it's written, it's feasible that a woman could go in to a clinic, ask for an abortion, get all the right to know information, be sent to a free clinic, have an ultrasound there, come back to the abortion provider, and all she has to do is sign that she had the opportunity to review that. What's going to really happen is any abortion provider isn't going to rely, with these severe penalties, isn't going to rely on an ultrasound done by an unknown third party. So it's really feasible that up to 2 or 3 ultrasounds could be done. That's a waste of resources. There's obvious concerns regarding HIPAA compliance and confidentiality provisions, a decrease in quality of care. We talked a little bit about that, no oversight. And it's contrary, in fact, to the current materials for the women's right to know. Those materials proclaim that they are to provide medically accurate information, and it states in those materials that the gestational age is usually determined by the last menstrual period. That has been done for ages on end. That's how it's done in OB offices today, and that's all that absolutely has to be done with respect to getting an abortion in early term. The Women's Right to Know Act also correctly states that the risk of complications increase as time goes by during a pregnancy. What this bill does is puts in another layer of delay. You're going to push back the possibility of the very early term abortions, cause more risk for the mother, more expense for the system. And finally, well, there was a mention last session that other states have enacted similar bills, and that's true. Indiana and Michigan have on their books an ultrasound bill. However, in both of those states, neither the viewing nor the ultrasound are mandated. The women are supposed to be provided opportunity to view and the availability of. They are not mandated to take a medically necessary test. Let me just see. With respect to the vagueness provisions, I just have to point this out because, I went to law school. You'd think I'd be able to read. But on Section 6, I have the short version. I don't have the long version y'all have, but that's under the penalties. Not only does it provide for medical malpractice action against we're not sure whom, the referring physician, the abortion provider, the free clinics that don't perform an appropriate ultrasound. But then it goes on, it says that the disciplinary board, the composite state board, can take action. There was no evidence from last time, and I'm not sure if there will be this time, whether the composite state board agrees with that provision or even has the resources to enforce anything like that. And then the third provision provides for a basis of recovery for the woman for the wrongful death of her unborn child under this chapter, whether or not the unborn child was born alive or was viable at the time the abortion was performed. So it's open to lots of readings. It provides almost a burden so tough on the referring physicians and the abortion providers that the effect of this will be a silencing effect and withdrawal from those providers, which I'm sure is the intent of this bill. And I know I went through those very quickly, but I'll be happy to answer any questions. Oh, and I agree with the first speaker that obviously this bill does not have an exception for incest, rape, or medical emergency. If you can tell me how a physician is going to have to require a woman to view an ultrasound before a medical emergency, during a medical emergency, that really is impinging on the medical practice and is not appropriate. So if nothing else has changed, we ask that that be included as well.
Questions from the committee. Representative Abrams.
For speaking, under your reading of the Act, who is actually at fault if a woman fails to receive an ultrasound, fails to undergo the ultrasound procedure because it is invasive or because she cannot afford it, and still signs a certification saying that she did, and a doctor relying on that certification performs the abortion? Who is actually at fault? Who's liable in that circumstance?
It's not clear. That's one of the issues that's why it's void for vagueness. It's not clear. It may be the woman. You know, as the physicians, if I were representing the physicians anywhere in the line, I would say if they did what they were supposed to do, then they're not liable. How do they prove that? And that goes back also to the enforcement of this. How the heck are you going to enforce this? Is this means the state's going to come into every OBGYNs and get a list of names of anybody who's had an abortion? And it's just a gross invasion of privacy. But, sorry. Go ahead.
My second question for you is, you spoke of the nature of an ultrasound for the first trimester being one of being an invasive procedure as opposed to the external procedure for the second trimester. Is it correct that 88% of abortions performed, to your knowledge, that 88% of abortions performed in the United States are first trimester abortions, so in the first 9 weeks, as opposed to that second tier of abortions, which are much rarer in the second trimester?
It's my understanding that's what the medically peer-reviewed materials say.
So under your reading of this law, it would require most women to undergo not one but two medically invasive procedures in order to make the decision to have an abortion.
Yes, and then she's not even required to view it, nor is her physician.
Thank you.
Chairman Franklin.
Mr. Chairman, did I understand correctly that you are the general counsel for Planned Parenthood?
Yes.
How many abortion facilities does your organization operate or are affiliated with in the state of Georgia?
They're affiliated with. Planned Parenthood of Georgia, Inc. doesn't have one, but they're affiliated with one in Augusta.
And that's the only one that Planned Parenthood is affiliated with?
Yes.
Do you charge for those abortions?
I believe they do. I'm not
Do
that
you know
degree.
Do you know how much revenue is booked as a result of abortions at your
No.
one facility in Georgia?
No.
Do they charge for an ultrasound?
I would imagine that they would.
So if this bill passes, that would increase your organization's revenue?
It may.
Thank you.
Certainly wouldn't help us. Any other questions?
Further questions from members of the committee?
Yes, Mr. Chairman.
Representative Everson.
Thank you. Are you aware of any births that are given that do not require ultrasound?
Am I? I'm sorry.
Are you aware of births that are taking place in the state of Georgia where ultrasounds are not performed?
No, but I'm not an practicing OBGYN.
Oh, I was just...
I don't know. I don't have any one way or another on that.
Okay, thank you. Our next question is, you mentioned something about standard of care for ultrasound and during pregnancy. What is that? What is the standard of care?
Is my understanding, and I base this on review of materials and Dr. Swiak's testimony, who's a professor of OBGYN, is that, and actually what I can speak to is from my own practice. I had an ultrasound in about the 5th or 6th month of both of my pregnancies. I had a spontaneous abortion, and I did not have an ultrasound.
Okay. Thank you.
Chairman Cooper.
Thank you, Chairman. Mr. Chairman. The answer to that question is, in the first trimester, ultrasounds are not routine and done only if there's a suspected problem. They are, I think, probably almost everyone would have one in the second trimester.
Do you have a question? Okay. Representative Collins.
I want to go back to something you stated earlier, and when you were going through your list of possible problems here. I'm familiar with an equal protection claim, but I'm also familiar with the fact that the courts have stated on many occasions that just because a law or a ruling is unfair, may be perceived unfair to one side or the other, it does not rise to the level of an equal protection violation. Could you please explain a little bit further what your point was in bringing an equal protection concerning the lack of care? Because right now, the way you framed it just a moment ago, you've got an equal protection violation in a sense where a suit could be brought because they don't have the access to regular normal care. I'm sort of vague on what your question is, and I would like to hear your comment on it.
Well, I don't know what case or what law you're referring to, but a lot of the finding of a violation of the 14th Amendment is very fact-specific. And the point of my making that argument, I cannot stand here and say this absolutely passes muster under the 14th Amendment or it absolutely fails. What I can say is the way it's written, it's highly susceptible to a 14th Amendment claim, and it may very well be found invalid, which of course would be my hope. And the courts, you're right, it's a balancing act. They look at how much burden, how many people are affected, and I don't have all of that data here, but I know that the abortion providers in Atlanta provide ultrasound, but there's a lot of providers all throughout the state of Georgia that do not.
So in essence, what you're saying is if you were bringing a lawsuit, this would be one that you would throw in amongst many to challenge this suit. Is that what you're saying?
Yes, as written.
Although you're really, at this point, as you just stated, have no true feeling on whether it would be taken in light or not, this would just be something that you feel like is thrown in to sort of damage this bill.
Of course, I'd research it before I did it, but I go back to my torts professor, sue on all claims.
Well, and that brings up an entirely different problem we have in our society, but thank you very much.
That's a tort reform issue.
I would love to chase that one, but, Mr. Chairman, we've got other things to do. Thank you.
We've already done that, tort reform.
No further questions?
Thank you
very
for
much.
allowing me to be here.
Thank you very much. Did Sadie Fields leave? Mary Boyer.
Thank you for letting me speak, Representative Ralston. I am here on behalf of the Archdiocese of Atlanta as the pro-life director for the Archdiocese, and we do support this bill, although we wish that abortion were not legal, but we do support this bill because we do feel it's very important that a woman have as much knowledge as she possibly can have before she makes this serious and important decision to abort her own child. I did bring some materials with me, but there have been a number of legal questions that came up, and I really, if it's all right, can I defer to Frank Mulcahy, who is the attorney who works for the Catholic Conference, because I can't answer the legal questions.
If you could ask a legal question, we'll let him come up. You may not get asked one.
I do know there was a discussion about medical emergency, and I can tell you very clearly that this bill does have an exception for medical emergency. It falls under the current Woman's Right to Know law. That I know, and I can understand that much because I can read that.
Okay, thank you. Did you have some material to distribute? Yeah, Daniel, you want to get that? Thank you very much. I'm sorry, were there questions of a non-legal nature from Ms. Boyers? Representative Levitas?
Actually, Mr. Chairman, my hope is to get legal counsel to answer the previously asked questions regarding the strict liability.
Okay, if you don't mind. Any other questions, though, from Ms. Boyer? Thank you very much. We got you up here just for questions, I think.
I think so, Mr. Chairman. Let me just tell the members of the committee, I'm Frank Mulcahy. I'm the executive director of the Georgia Catholic Conference, representing the 2 Catholic bishops of Georgia. And I am an attorney, so I guess we'll have questions. Yes, sir.
Representative Levitas.
Thank you, Mr. Chairman. Thank you for being willing to answer these questions. I'm an attorney, but I'm mostly a recovering attorney, so I'm going to defer to you on this. And if you would start in your response just by explaining to members of the audience who may not be familiar with what strict liability is, if you can just give an explanation of that. And I would pose to you the same question that I posed to one of the previous speakers, which is, under the law as drafted, under the subparagraph 3, under Section 6, on page 7 of the long version at line 3, as I read this statute, it would provide a per se, meaning just by virtue of the fact that the sonogram was not performed, a basis for a wrongful death action. In other words, if it was proven that the sonogram or the statute in some way was not complied with, that's an example of failure to comply, that in and of itself would be the basis for a wrongful death action against the doctor who did not comply with the law. Is that how you read that section?
Well, let me start. You asked about strict liability. Strict liability generally means that if you do the act or fail to do the act, then you're liable. So there's no question of fault or negligence or anything like that. Strict liability is, you see a lot of in consumer products. If the can of beans blows up, then often it's not your fault, so you didn't do something to it, but you have the company would have strict liability. With regard to this section, I think particularly subsection 3, I think, first of all, to say it's strict liability, I don't think it goes quite that far. It provides the basis for recovery, assuming there are damages. And assuming there are damages that are, contrary to what the patient, in this case the woman, has asked to have done. I certainly would not see this as strict liability. A woman goes in, has an abortion, whether the sonogram is done or not, and then turns around and says, I can get some free money by suing the provider. She went in and she asked for the abortion. I think if the abortion happens the way she wants it, correctly, then you can't see whether there be any damages.
Mr. Chairman, may I follow up with two brief questions? You bring up actually a very good point. I'm glad you did, because I wanted to ask you about this one as well. You've made the assumption in the response to your question that the cause of action will be brought by the woman. Conceivable under this as drafted that the father or even a third party on behalf of the child could file that action, isn't it? Conceivable as drafted?
I think that's possible, yeah.
And then I wanted to follow up on one more question. You were talking first about liability, whether somebody is at fault or responsible for something that happened. But then you moved on to damages. Really, my question is not whether or not the individual who brings a suit, and as we've established that it's the basis for such a suit, but whether by virtue of violating a provision of this statute, that in and of itself forms the basis for recovery separate and apart from whether you can prove any damages. Is that your understanding as drafted of the statute, this particular subsection and subparagraph?
I think so.
Okay. Thank you. I have no further questions. Thank you, Mr. Chairman.
Representative Abrams.
Going back to Representative Levitas' earlier question about strict liability, and this is a repeat of my question to the General Counsel for Planned Parenthood, assuming that, under your reading of the Act, assuming that a woman falsely certified that she received an ultrasound that she did not receive, and a doctor relying on that information performs an abortion, would that doctor be liable under strict liability standards for violating provision of 3? So would he, or she, could they still be held accountable and held liable if they relied on false information, if this is read as a strict liability statute?
I don't think the physician could be held liable. If anything, probably, particularly with some of the amendments we have floating around right now, the woman might be liable for anything that happened because she had misrepresented a fact. Now, let me put it the other way. The physician, I wouldn't think, could be held liable for something that happens when the patient lied about the thing that she should have informed him of.
Further questions? Thank you, sir.
Thank you, Mr. Chairman.
Donna Perry.
Good evening. It's a privilege to get to address your distinguished body. My name is Donna Perry. I'm the Executive Director of the Pregnancy Resource Center of Gwinnett. We are a nonprofit organization that provides a community service to our clients at no charge. We exist to equip women who are seeking information that can empower them to make a fully informed decision about their pregnancy. This includes offering a free ultrasound for clients who qualify. We are a medical clinic, and we operate under the supervision of a licensed gynecologist who reads every ultrasound that we perform. We have trained, certified medical professionals, including a registered diagnostic medical sonographer, and they perform limited ultrasounds under the guidelines of the American Institute of Ultrasounds in Medicine. We saw almost 1,700 clients in 2006, and we performed almost 498 free ultrasounds during 2006. We offer the ultrasounds to provide medically accurate, medically based, truthful information to our clients regarding their pregnancy and their own health. It's quite possible that we offer the earliest prenatal care in Gwinnett County. A client with a positive pregnancy test can be transitioned from the counseling room into the ultrasound room within 15 minutes of having received her positive pregnancy test. This enables us to alert her in the early stage of her pregnancy to the possibilities of maybe an ectopic pregnancy, of multiple births, or the lack of a fetal heartbeat, which could be an indicator of a possible pending miscarriage. It also provides her with visible information regarding fetal development. We have had many clients, upon receiving an ultrasound, say, I had no idea. And they express their surprise when they see the image on the screen. The ultrasound services that we provide have proven to be a valuable, yet free, resource to our community because we have alerted many clients to possible health risk and have provided useful information as they face a very profound decision in their life. Thank you.
Thank you very much. Questions from the committee? Thank you. Here's what we're going to do. I want to take, are there any, because I don't know now, opponents of the bill who have signed up that I have not recognized? Okay. It's almost 6 o'clock. Those of you who support the bill that have signed up, do any of you live further away than Franklin County? I know you've been here twice, and I know where Franklin County is. So you're going to be our last speaker, Ms. Brock.
Thank you, committee. And this is probably going to be pretty hard for me, and I appreciate you recognizing me. There's a couple of things. I am from a rural community, and that was where I was when I had where I was living when I had my abortion. I didn't mind driving 100 miles, or my mom and an older sister. And by the way, life means more to me today than last year because I lost my mom in December. And life is a precious, precious issue to me. And it wasn't a burden to drive to Atlanta to get an abortion. If you want one, or if somebody wants you to have one, they're going to take you wherever. What is a burden is that you're not offered every possible chance to save the life of your child. I would have a 21-year-old had I not had that abortion. And my daughter is 17, and she knows the difference between life and death. She done a study in citizenship. She knows the difference between what abortion is and what it's not. And if you haven't seen the graphics, I'm sorry, they're ugly. They are ugly, but it's the truth. And I just have to share that I spent about 3 hours Saturday at a birthday party of a little boy. His name is Elijah. And his mom, at one point, and his aunt at another point, whispered to me and said, "Tina, you know, Elijah wouldn't be here if it wasn't for you." He had his 1-year birthday. This is what it's about. I was told it was a blob of tissue. Had they showed me an ultrasound, or at least offered one, knowing the person that I am, I could not have allowed what I see to be done. And I'm so saddened by the fact that while we've sat here and went through this day after day, every 22 seconds a baby is dying. And this is what my life is all about. We do offer free ultrasounds. A lot of the pregnancy centers out in our rural area are able to offer that. And we have had women change their mind from it. We are, I don't know, I'm sorry I'm so shook up, but a T-shirt. We see a lot of pro-life stuff, and I ran across a T-shirt that said, "In America, we're born to be free," and the little baby in the womb say, "Too bad we're not free to be born." And I just want to leave you with that thought, and if you have any questions for me, I do live way out there, and I'm probably the most country girl you'll find, and I do it out of the goodness of my heart because I love life and I love babies, and that abortion did affect me very much. When I had it, I went through a bout of depression. I wish that somebody had have shared more options with me, had have told me, just somebody to call. We offer a hotline. If somebody had just said, I'm there for you, we'll help you through it. But a life is a life, and I'm sorry I was not told. I was told it was a blob of tissue, and had they offered me that ultrasound, I would have seen that.
Thank you, Ms. Brock. Questions from the committee for Ms. Brock? Representative Lunsford.
Ms. Brock, I just want to say thank you for coming. I know it's a hard for you, and I do appreciate you standing here and telling your story. I only personally have 7 kids, so I understand what it's like. And by the way, 3 of them I did adopt, and it's very difficult for my children to adopt. It takes a long time, but I appreciate you understanding that.
Thank you.
Any other questions? You go back to Franklin County and tell them a country girl got to move to the front of the line, okay?
Thank you. Thank you.
Okay. We're now halfway through. We have 6 other people who had signed up, and we'll be getting out. We're going to keep this sign-up sheet, and I think in the interest of getting to a point where we can move, then we're not going to allow further sign-ups. But these people, if you still desire, at the next time we have one of these, we'll hear from you, okay? So we want to be fair. With that, we're going to stand adjourned. I've made subcommittee assignments. We will meet again in full committee Wednesday at 3 p.m. back over in our home. Meeting's adjourned.